For today's case, we take a look at a recent U.S. Supreme Court decision that deals with Indian children, children of Native Americans. Federal law exists on this issue in relation to tribes that attempts to give primacy as it relates to adoptions to Indian families, Native American families. First to the tribe, if possible, and if not, then to other tribes that might be comparable. This has been an issue, obviously, as it relates to adoptions, because some people might want to adopt the Indian children, but they have to deal with the fact that these children have primacy with tribes, and so it becomes difficult for some people to adopt, even if they have a close bond with the child that's been developed through some sort of foster care, for example. So the Supreme Court has taken a look at this issue as it relates to Indian children, Native American children, and the adoption issues, and spoken to this issue. So let's read and understand what's going on in this case. Let's get started with this. This case arises from 3 separate child custody proceedings governed by the Indian Child Welfare Act, a federal statute that aims to keep Indian children connected to Indian families. The act governs state court adoption because, federal primacy on the issue. The federal government, by the Constitution, has the right to govern the tribes. So federal primacy in this domain, probably not a problem because of the Constitution. And so there is a federal law and foster care proceedings involving Indian children. So state law and foster care law will bend to federal law in this particular domain. Fine. Among other things, the act requires placement of Indian child according to the act's hierarchical preferences, unless the state finds actual cause, which is pretty difficult to find in reality. Under the preferences, Indian families or institutions from any tribe, not just the tribe, which the child has a tie, outrank unrelated non-Indians and non-Indian institutions. So first, the tribe. If not, any tribe. If not, then other people. That's what we're doing. Further, the child's tribe may pass a resolution altering prioritization order. So if the tribe wants something different, then that's fine because the law allows for it. The preferences of the Indian child or the parent generally cannot trump those set by statute. So even if the parent wants something else, the federal law says no, because the federal law says this is what's in the best interest of the child. So the parent's wishes to the contrary will bend to the statute. Fine, that's what's going on. In involuntary proceedings, the act mandates that Indian child's parent or custody and tribe be given notice of any custody, as well as rights to intervene. So if the parent wants the adoption, then great. If not, if the child is trying to be taken from them, for example, by them being an unfit parent, for example, then they're entitled to notice, as you would kind of expect. So they have to be given notice. The law requires the party seeking to terminate parental rights or remove the Indian child from an unsafe environment to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent breakup of Indian families, and the court cannot order relief unless the party demonstrates by heightened burden of proof and expert testimony that a child is likely to suffer serious emotional or physical damage, even if the parent or Indian custodian retains custody. So yes, this is designed to be and is harder than a typical removal procedure, because the federal government, which has the right to govern relationships with the tribes by the Constitution, thinks that it's particularly important that Indian children be kept with fellow Indians, or Indians of any description, really, and also is concerned, in particular, that children might be taken away from their Indian parents because of differences in culture that aren't necessarily problematic for the child, at least in the traditional sense of the Indian relationship. So the burden is higher. It's designed to be higher. That's the way the federal government wants it. Even in a voluntary proceeding where the parent is totally cool with everything going on, the biological parent who gives up the Indian child cannot necessarily choose the foster or adoptive parents. So if the parents are like, yeah, cool, adoption's fine by me, but federal law still is going to intervene over here. The child's tribe has a right to intervene at any point in the proceedings to place a child in foster care or terminate parental rights, as well as a right to collaterally attack any state's custody decree. So the tribe gets to be an interested party and intervene in the lawsuit as a party. Fine. The tribe then therefore can sometimes enforce the placement of the acts against the wishes of one or both parents, even if the child is already living with a new family. So both parents are like, cool, this is fine by us. Foster parents are like, I have a super strong bond with the child. The acts over here like, we don't give a shit. Okay. Finally, states must keep certain records relating to placements and transmit to the Secretary of Interior all final adoption decrees and other specified information. Because federal government. So the federal government has a right to know what you're doing. Okie dokie. The petitioners over here, a birth mother, a foster parent, and adoptive parents, and the state of Texas, filed this suit in federal court against the United States. Several Indian tribes intervened to defend the law alongside the federal parties. The petitioners challenged the law as unconstitutional on multiple grounds. Okay. They assert that Congress lacks the authority to enact the law, and several of the law's requirements violate anti-commandeering principle of the 10th Amendment. Yeah, not so sure about that one, to be honest. Okay, so let's go over the basics. Anti-commandeering principle is a principle that's well understood that basically says the federal government, as a general rule, cannot force states to do their bidding. The federal government can't make state governments do stuff. They cannot take over state level apparatuses. If the federal government wants to enforce their laws, cool. Hire your own police, get your own courts, but don't talk to the states about it. You can't make the states enforce federal law. But is that true in this specific context? Because while there is a specific constitutional authority which gives the federal government the ability to regulate relationships with the tribe, so maybe that anti-commandeering principle needs to take a back seat. It's at least debatable, right? So it's like, okay, I'm not sure if the anti-commandeering applies in this context or not. But that's what they're talking about. Can the federal government make the state do stuff? All right. They argue the act employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. Yeah, but the Constitution, though. So I'm not sure that's a problem, but all right. And they challenge the relevant law, the provision that allows tribes to alter the prioritization order on the grounds it violates non-delegation, because we're giving it to the tribes themselves. But the tribes do have this status as domestic countries. So maybe that's a little bit different. Maybe they are a government because they're domestic countries. They're dependent domestic countries, I believe is the exact language in the federal statutes, if memory serves correctly. I think it's dependent domestic nations, I think is the exact language the federal government uses. What does that mean? But yeah, maybe because normally we can't give legislative authority to a private entity. That's the problem, right? Congress can't empower the Kennel Club to start passing regulations on dogs because it's a private entity. But the tribes are the tribes a private entity, but they're a dependent domestic nation. So maybe that's different. And maybe we just empowered the state government that is the tribes. Indian law gets complicated. Let's press on. The district court granted petition's motion for summary judgment on the constitutional claims, and the en banc Fifth Circuit affirmed in part and reversed in part. The Fifth Circuit concludes the act does not exceed Congress's legislative power, the relevant section does not violate non-delegation, and some of the law's placements satisfy the guarantee of equal protection. Yeah, the Fifth Circuit was evenly divided as to whether the other preferences, prioritizing other families and Indian foster homes over non-families, unconstitutionally discriminates on the basis of race. Even if it is discrimination on the basis of race because of direct constitutional authority, it might be legal anyway. Maybe the discrimination on the basis of race is totally fine because the Constitution does talk about the federal government's ability to, deal with the relationships with the Indian tribes. So is it racism? Maybe. Is it legal? Quite possibly. Let's press on. As the petitioner's 10th Amendment arguments, the Fifth Circuit held that the active efforts requirement and the expert witness requirements and record-keeping requirements unconstitutionally commandeer the states. Questionable. Tribes, that anti-commandeering principle is important and all, but these are dependent That dependent domestic nations. And so, maybe that's different. This is constitutional nightmare fuel because of all this stuff. This is how we have fun in Constitution land. Okay. And because it divided with respect to these other challenge provisions, notice requirements, and placement preferences and record keeping, the Fifth Circuit affirmed. No problem. The Supreme Court's here to come to the rescue and help clarify all these wonderful constitutional nightmare fuel. So let's figure out what the law is. That's great. All right, let's press on. All right, held. The court declines to disturb the Fifth Circuit's conclusion. The act is consistent with the Article 1 authority. So the act is constitutional. Okay. The court has characterized Congress's power to legislate with respect to Indian tribes as plenary and exclusive, superseding both tribal and state authority. Yeah, I mean, that much is true. The United States government's authority over the tribes is absolute. So, yeah, okay, fine. The court has traced that power to multiple sources. First, the Indian Commerce Clause authorizes Congress to regulate commerce with the Indian tribes. And the court has interpreted the Indian Commerce Clause to reach not only trade, but also Indian affairs. The Treaty Clause provides a second source of power. The treaty power does not literally authorize Congress to act legislatively, since it's housed in Article 2, but treats treaties made pursuant to that power that can authorize Congress to deal with matters which otherwise Congress could not deal. Also, principles inherent in the constitutional structure may empower Congress to act in the field of Indian affairs. Finally, the trust relationship between the United States and Indian people informs the exercise of the legislative power. In sum, Congress's power to legislate with respect to Indians is well established and broad, but is not unbounded. It's plenary within its sphere, but even a sizable sphere has borders. Ooh, exciting. So it's absolute within the boundaries, but then we get to play with the boundaries. Fun. Petitioners contend that the act impermissibly treads on states' traditional authority over family law. But when Congress validly legislates pursuant to Article 1, the court has not hesitated to find conflicting state law preempted, notwithstanding the limited application of federal law in the field of domestic relations generally. Yeah, the federal government doesn't have a lot of authority when it comes to family law, but the tribes, though. So, yeah. And the court has recognized Congress's power to displace the jurisdiction of state courts in adoption proceedings involving Indian children. Sounds about right. Yeah. Petitioners contend that no source of congressional authority authorizes Congress to regulate custody proceedings for Indian children. They suggest that the Indian Commerce Clause, for example, authorizes Congress to legislate only with respect to Indian tribes as governmental entities, not Indians as individuals. Fair. But this court holding more than a century ago that commerce with the Indian tribes means commerce with individuals composing those tribes renders that argument a dead end. Dude, is that really what they meant? Literally? Okay. I mean, I guess I could go reread that case. But, do they literally mean that the Indian Commerce Clause really speaks to each particular individual? Did they mean that literally? In that case, I have questions about that one. I have my doubts they meant that literally, Supreme Court. I mean, you're quoting yourselves, but I'm not sure you're quoting yourselves faithfully on that one. Yeah. Petitioners also assert that the act takes commerce out of the Indian Commerce Clause because children are not commodities that can be traded. Yeah, I mean, looking at adoption proceedings as commerce is one strange way of looking at commerce. This point, while rhetorically powerful, ignores the court precedent interpreting the Indian Commerce Clause, not only with respect to trade, but other Indian affairs. Children are commerce now. Children are commerce. Okay. Children are commerce. I guess that federal law can authorizes the children to be bought and sold on a market now. Exciting. It means the federal government can take them and sell them at some sort of market. That doesn't raise any sort of dark utopian nightmare problems. No sirree. Okie dokie. Children are commerce. Let's not think about that too hard. Petitioners next argue the act cannot be authorized by a principle inherent in the Constitution structures because those principles extend at most to matters of war and peace. Again, petitioners make no argument this takes the court cases on their own term. The court has referred generally to powers necessarily inherent in any federal government and has offered non-military examples such as creating departments of Indian Affairs. Petitioners next observe that the act does not implement a federal treaty, but Congress did not purport to act pursuant to a treaty, and the Fifth Circuit did not uphold it pursuant to that rationale. Finally, petitioners turn to criticizing the court precedent as inconsistent with the Constitution's original meaning, but they neither ask the court to overrule the precedent they criticize, nor try to reconcile their approach with it. If there are arguments that the act exceeds congressional authority, as precedent stands today, petitioners do not make them. Really? Really? Petitioners didn't challenge the constitutionality didn't challenge the precedent? Seriously? This seems like you're trying to be real cute, Supreme Court. This is like, well, they never technically asked us, so we don't have to answer the question. This seems like you're being very, very cute right now. I don't know about that one either. Petitioners' anti-commandeering challenges, which address three categories of the act, are rejected. First, petitioners challenge certain requirements that apply in the involuntary proceedings to place a child in foster care or terminate parental rights, focusing on the requirement that the initiating party demonstrate active efforts to keep the family together. Petitioners contend this subsection directs state and local agencies to provide extensive services to the parents of the children, even though it's well established the 10th Amendment bars Congress from commandeering the states or those political subdivisions to administer or enforce a federal regulatory program. Well, that is typically true. Is it true here? To succeed, petitioners must show that the act harnesses a state legislative or executive authority. But the provision applies to any party who institutes proceedings, thus sweeping in private individuals and agencies, as well as governmental agencies. A demand that either public or private actors can satisfy is unlikely to require the use of sovereign power. Okay. Petitioners nonetheless insist that states institute the vast majority of the involuntary proceedings. But examples of private suits are not hard to find. Well, that kind of defeats the point. Yeah, I mean, most of the time, it's the state that's trying to take the children away from parents in an involuntary manner. Yes, private parties can do this. Yes, you can find examples, but that doesn't really undermine the point that the state is usually the one doing this. But okay, let's pretend it does. Examples of private suits are not hard to find. And while petitioners treat active efforts as synonymous with government programs, state courts have applied the active efforts requirement in private suits too. That's consistent with the Act's findings, which describe the role that both public and private actors played in unjust separation of children from their families. Given all this, it's implausible the Act is directed primarily, much less exclusively, at the states. Legislation that applies even-handedly to states and private actors does not typically implicate the 10th Amendment. Petitioners would distinguish the court's precedent, so holding on the grounds those cases address laws regulating a state's commercial activity, while the Act regulates core sovereign function of health and safety for children. This argument is presumably directed at situations in which only the state can rescue a child from neglectful parents. But the state is not necessarily the only option for rescue, and the Act applies to other types of proceedings too. Petitioners do not distinguish between these varied situations, much less isolate a domain in which only the state can act. If there is a core of involuntary proceedings committed exclusively to the sovereign, Texas neither identifies its current contours nor explains what the Act requires of the states in that particular context. Again, it feels like we're trying to be too clever. It feels very much like we're really desperately trying to avoid the issue. We're grasping at straws a little bit, it feels like, Supreme Court. I have to be honest. And the petitioner's challenge for other provisions of the Act, the notice requirement, expert witness requirement, and evidentiary standards, the court downs to the requirements placed on the state as litigant implicate the 10th Amendment. But regardless, those provisions likely apply to both private and state actors, and so pose no anti-commandeering principles. Okay. Sure. Why not? How are we doing over there in chat, by the way? I see I lost most of the people watching the chat. I guess some people are not interested in U.S. Supreme Court. How are we doing over there in chat? We following along? Even though it's kind of a little nebulous. Okay. Yeah. Yeah. Petitioners next challenge the Act's placement preferences. Petitioners assert that the provision orders state agencies to perform a diligent search for placements that satisfy the Act's hierarchy. Just as Congress cannot compel state officials to search databases to determine the lawfulness of gun sales, Congress cannot compel state officials to search for federally preferred page placement. We're comparing Indian children to firearms? That seems like a okay. As with the Act, they have not shown the diligent search requirement, which applies to both public and private parties, demands the use of state sovereign authority. Moreover, the Act does not require anyone, much less the state, to search for alternative placements. Instead, the burden is on the tribe or other objecting party to reduce the higher ranking placement. So, as it stands, petitioners assert an anti commandeering challenge to a provision that doesn't commandeer the state agencies to do anything. Okay. States' courts are a different matter. The Act indisputably requires them to apply placement preferences in making custody determinations, but Congress can require state courts, unlike state executive and legislative, to enforce federal law. Fair enough. I mean, that is a point of distinguishment. So, sure, petitioners draw a distinction between requiring state courts to entertain federal causes of action or requiring them to apply federal law to state causes of action, but the argument runs counter to the supremacy clause. When Congress enacts a valid statute, state law is naturally preempted to the extent of the conflict. That a federal law modifies state law cause of action does not limit the preemptive effect. Okay. Finally, petitioners insist that Congress cannot force state courts to maintain or transmit records of custody proceedings involving children. But the anti commandeering doctrine applies distinctively to state courts' adjudicative responsibilities. The Constitution allows Congress to require state judges to enforce federal prescriptions insofar as those prescriptions relate to matters appropriate for judicial power. In Prince, the court indicated the principle may extend to tasks that are ancillary to quintessentially adjudicative tasks, such as recording, registering, and certifying documents. Prince describes numerous historical examples of Congress imposing record keeping and reporting requirements on state courts. These earlier congressional enactments demonstrate the Constitution does not prohibit the federal government from imposing adjudicative tasks on state courts. The court now confirms what Prince suggested. Congress may impose ancillary record keeping requirements relating to state court proceedings without violating the 10th Amendment. Well, as it extends to courts, I guess that's fine. So fine. Here, the Act's record keeping requirements are comparable with a historical example. The duties imposed are ancillary to the obligations to conduct the proceedings in accordance with the Act. The court does not reach the merits of petitioners' two additional claims: the equal protection challenge to the Act's preferences and the non-delegation challenge, the provision allowing tribes to alter placement, because no party before the court has standing to raise them. Okay. So we're not going to raise equal protection or non-delegation because no one has standing? Okay. The individual petitioners argue the Act's hierarchy of preferences injures them by placing them on unequal footing with Indian parents who seek to adopt or foster children. But the individual petitioners not shown this injury is likely to be redressable by judicial relief. They seek an injunction preventing the federal parties from enforcing the Act, and declaratory judgment the Act challenged the provisions are unconstitutional. Yet enjoining the federal parties would not remedy the alleged injury because state courts apply the placement preferences and state agencies carry out the court order placements. The state officials who implement the Act are not parties to the suit, and there's no reason they should be obliged to honor the incidental legal determination suit produced. Petitioners' request declaratory judgment suffers from the same flaw. The individual petitioners insist that state courts are likely to defer to federal courts' interpretation of federal law, thus giving rise to substantial likelihood that judgment will redress their injury. But such a theory would mean redressability be satisfied whenever a decision might persuade actors who are not before the court. It's the federal court's judgment, not its opinion, that remedies the injury. The individual petitioners can hope for nothing more than opinion, so they can't satisfy Article 3. Oof. Dude, we're dancing on the heads of pins over here big time. We're dancing on the heads of pin big time. Woof. How does no one have standing? Well, we haven't gone to the equal protection part yet. Texas has no equal protection rights of its own and cannot assert equal protection claim on behalf of its citizens. The state's creative arguments for why it has standing despite these rules fails. Texas arguments that the act requires it to break its promise to its citizens. They'll be colorblind in custody proceedings is not the kind of concrete, particularized invasion of protectable interest necessary to demonstrate injury in fact. Texas also claims a direct pocketbook injury associated with costs of keeping records, providing notice, and producing expert testimony before moving a child. But these alleged costs are not fairly traceable to the placement preferences, which operate independently of the provisions. Texas would continue to incur the costs even if we were relieved of the duty to apply the preferences. Because Texas is not injured by the preferences, neither would be injured by the tribal resolution that altered those preferences. Texas does therefore have standing to bring its equal protection. Okay. And although the individual petitioners joined Texas non-delegation challenge, they raised no independent arguments about why they'd have standing. What? Why don't they have standing? What? Barrett delivers an opinion in which Robert, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Jackson join. Thomas and Alito dissent. Thus, that brings us to the end of this discussion about the Indian Child Welfare Act and its relation on adoptions in the United States. Long story short, tribes are different, is basically what this fundamentally boils down to. The commandeering principle doesn't really apply because we're only ordering courts to do things, and we can do that because they're required to uphold the law. And the private parties can also do the required showing of the steps they took to help with the family. So this isn't a burden on the states. But to be honest, it feels a little bit like we're going a little bit out of our way in some of these parts. So it feels a little like we're dancing on the head of a pin. And I'm not 100% sure the Supreme Court is quoting its own precedent right on some of this stuff. So, yeah. But I think it's basically because tribes, though, they find that the Congress has the plenary power with respect to tribes, and this is part of the tribes. So it's all good. And the commandeering principle doesn't apply because it's an order to states, and the record keeping arguments don't apply because it's ancillary as part of the judicial role. And so keep doing that in a 7-2 decision. So interesting, a little bit questionable in parts, a little bit dancing on the head of a pin. But that for the moment brings us to the end of discussion of this case.